Hello, everyone. This is Mary Jones, Senior Education Consultant with Husch Blackwell's Higher Education Group. Thank you for joining us today for our webinar, Before the New Title IX Rules Drop. We'll be talking with you about best practices that can be put in place in anticipation of the new Title IX regulations. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console are multiple application icons for your use during the program today. I'd also like to take a minute to highlight a few of those for you. If you have any questions during the webcast, please submit your questions via the question box. I know that we're likely not going to get to all the questions today, but we'll look at the questions and do our best to answer the ones we can today. And if we run out of time, which is likely, or we need to get back to you, we will answer that later by email for you. We really do appreciate your participation and encourage you to submit questions. There's also an icon to help you with your viewing preferences. You can expand your slide area by clicking on the maximize icon at the top right of the slide area, or you can drag the bottom right corner of the slide area to adjust the size. If you have any technical difficulty, please click on the help icon. It has a question mark and provides information regarding some common technical issues. Please be aware that the Chrome browser works best. And if you do have an issue, try refreshing your screen with F5 because that solves a lot of issues. A copy of today's slide deck and additional materials are available on the resource list icon, and that looks like a folder at the bottom of your screen. This program has been approved for continuing legal education credit for Colorado, Illinois, Iowa, Kansas, Missouri, Nebraska, and Tennessee. It is pending approval for Indiana, Texas, and Wisconsin credit. To report your hours in Illinois, Indiana, Kansas, Nebraska, Tennessee, or Texas, click on the CLE widget at the bottom of your screen and complete the questions. You may also download the certificate of attendance from the certificate widget at the completion of today's program. Also, a recording of the webcast will be available tomorrow for watching and sharing. And once available, a link of the recording will be emailed to you. Our two speakers today are members of Husch Blackwell's Education Group, Julie Maselli, Office Managing Partner, as well as attorney Mary DeWeese. Both are education-focused attorneys passionate about helping organizations to serve students and advance their missions. Julie and Mary represent educational institutions in state and federal litigation and administrative proceedings. They conduct investigations, and they provide counsel on administration, Title IX policies, student matters, and employment issues. Julie, these have been incredibly challenging days for everyone on our webinar day. Would you please start us off?
Absolutely. Thank you, Mary Jones. And hello, everybody. Welcome to our webinar and happy Monday. My name is Julie Maselli, and I want to first start by acknowledging what unprecedented and unusual times we find ourselves in. I'm guessing, like myself, many of you are sheltering in place and may be listening to this webinar from your home. We know that there are many of our clients and our colleagues in the higher education sector who are being directly impacted by the COVID-19 pandemic. And we know how many of you are facing very novel and challenging issues. And we're happy to have this webinar today so that we can talk through some of those and try to give you in the Title IX sector some additional guidance on those issues. On behalf of myself and my colleagues in the education team at Husch Blackwell, we hope that all of you out there, your families and your colleagues are all healthy and that you are 6 feet safe is what we're calling it. I want to also send a little shout out to those of you with medical, nursing, and allied health programs. We know you are all moving a mile a minute to support the healthcare demands within your communities, and we are so grateful for your work. So we just wanted to send a shout out to all of you as a thank you. Many of you know that the webinar that we originally scheduled was designed to dig into emerging Title IX practice trends that we believe schools should be considering in advance of the Title IX regulations. In light of how the world has changed in the last few weeks, what we believe may be most pressing for Title IX practitioners, though, has shifted a bit. So we've modified the webinar slightly in that we do want to get to some of the content that we had planned for this webinar originally, but our primary goal has shifted. We want to make sure we're providing you with the most practical and impactful information on how to continue your Title IX practice in a time where so many of you have moved to online or are facing other challenges caused by the COVID-19 pandemic. As Mary mentioned, I'm joined by my colleague today, Mary DeWeese, who will be sharing with you some tips for completing investigations in this unprecedented time, providing interim measures and thinking creatively about what those may look like as you have students scattered across the country, and how can you process new complaints in a time like this when your resources and staffing may be impacted by the pandemic. We will also provide a brief overview of those emerging trends that I talked about earlier that we had originally planned, but we want to make sure we're leaving room for questions, which we anticipate may center around COVID-19 response. So before I do that, let's first turn to what I know is top of mind for every Title IX practitioner, which is when are the new regulations expected? What I can tell you is I just checked Twitter and every Education Trade Association magazine I can find, and so far, as of this morning, nothing has been released, and I think you're all aware of that, but I have been in a presentation where new Title IX information dropped in the middle of my presentation, so I know to check Twitter before I get on. Let me talk to you about what we do know on these Title IX regulations. In light of COVID-19, there have been multiple calls within the education sector for the Department of Ed to not release the Title IX regulations now. The argument has been laid out very clearly that this is a very difficult time for higher education to be responding to a radical shift in the regulatory framework for Title IX. We have not heard a response from the Department of Education yet to those calls, and we can only be hopeful that the department will respond to those in the coming days or weeks. Up until that point, there had been pure rumor and pure speculation that the release of the final rules would appear to be about now-ish, or even last week was the last thing that we had heard. At the same time, the Office of Management and Budget, which is a critical federal agency that oversees the regulatory process, has scheduled meetings with stakeholders about the Title IX regulation and proposed form through April 16th. So we know that these meetings are continuing. In looking at OMB's calendar, we can see that meetings that were scheduled over the last couple of weeks in fact did occur, but that they were occurring in teleconference form. So we have no reason to believe that those meetings wouldn't continue. OMB's meetings are not a precursor or condition to the Department of Education finalizing the rules. Those meetings can be canceled at any time, but we like to believe that they are a guidepost for when the regulations may come out, and that the department would honor those commitments to stakeholders that they decided that they would meet with through this process. We also have to keep in mind that this is an election year. We know that the Department of Education is motivated and remains motivated to release these final rules. One of the motivating triggers for this is that rules that are not finalized soon can be subject to being overturned by Congress through a mechanism called the Congressional Review Act. Essentially, and I feel like I'm having deja vu because I know we talked about this just 4 years ago when administration was, when there was an election year and we were concerned about the administration and Congress shifting power, is that every time you have that, every 4 years, Congress has an opportunity to look at what they call sort of the 11th hour midnight rules, or rules that occur in the last several months of an administration. If there's a shift in Congress and in power, Congress has in the past looked back at those administration rules that have been enacted in the last 6 months and used the Congressional Review Act to roll back some of those regulations. That was something that we saw with this administration, in that a number of the Obama-era regulations were looked at under the Congressional Review Act for repeal. It's possible that if these regulations, the Title IX rules, are not released sometime by this summer, they start to hit that danger zone. The Congressional Review Act specifies that Congress has 60 legislative days in order to look at any rules that have been recently enacted. Now, that doesn't mean we just look 2 months behind or in front of the election. Because Congress is not in session for all of those days, we have to look at the legislative calendar. And looking at that calendar, it looks like sometime around June, July starts to look like a potential danger zone given how many congressional days Congress has committed to being in session. So we are in a waiting period, as we have been. I remain hopeful that the regulations will be put on pause because I know how disruptive a radical regulatory shift could be at a time like this for higher education. We will have to wait and see if the department responds to those calls by the sector to hit the pause button on these rules. So with that, I want to turn to my colleague Mary, who's going to start by walking through some of the issues that we've already been hearing from our clients about how do we continue our Title IX practice while we're also dealing with a global pandemic, and how can we structure our processes to be fair, responsive, and prompt for the parties that we are trying to serve. So with that, Mary, I'll turn it to you.
Thanks, Julie. So as Julie mentioned, COVID-19 has upended, well, everything. We know you've all moved into this scenario with students off campus using remote learning tools. We're going to give you some pointers on fulfilling your Title IX obligations in light of this pandemic and the corresponding remote learning, as well as discuss some unique practical and legal considerations that you should keep front of mind. As you're aware, your Title IX obligations are continuing even in light of the current pandemic. Now, there's certainly no certainty with regards to how the Department of Education and OCR will respond to compliance issues arising from the present emergency. In times of emergency with past departments, we've seen the department take reasonable action to alleviate the school's responsibilities. For example, providing extensions in OCR matters. As such, we think it's likely that this department will be somewhat lenient with respect to certain Title IX compliance requirements, most likely deadlines, for example, but we don't know for sure. Moreover, as a matter of policy, the proposed regulations appear to establish recognition of flexibility and tolerance. This will be a guidepost that, especially during this time of disaster, it's not the time for nitpicking technical compliance issues. However, we still expect the department to be on the lookout for systemic problems. Moreover, Congress and the department are not going to waive any civil rights laws. As such, even if the department is lenient, a failure to investigate opens the university up to a deliberate indifference claim, which, as a reminder, is a civil rights claim brought against a school. So while there's likely some flexibility as we adjust to online learning investigations, you cannot, as a rule, push off all Title IX investigations and adjudications until students are back on campus. We're going to go more deeply into conducting remote investigations, but I wanted to briefly touch on OCR. If you currently have an open OCR investigation and need more time to respond, we advise that you talk to the investigator. We don't know for sure, but we anticipate that they'll be understanding. A reasonable request for more time to gather information, talk to witnesses, produce documents, and draft your position statement will likely be granted, provided the delay is not indefinite. Before we get into our best tips for remote investigations, we have our first poll question of the webinar. Please take a moment to answer. Are you currently using audiovisual platforms to conduct investigations remotely? We know a lot of you out there have been adopting remote tools for your regular load of cases pre-pandemic. This is especially useful for colleges that use outside investigators who may be located remotely. Both Julie and I have conducted such remote investigations ourselves. So as you can see, many of you, over half of you, have done some remote investigation work. We hope this provides reassurance to those of you that mainly conduct in-person, on-campus investigations that this can be done. Of course, the current pandemic raises its own unique issues. We hope you walk away from this presentation with practical strategies to implement. So as I've noted, we've investigated cases ourselves in a remote way, and it can be very successful. As a preliminary matter, it's harder to build trust with the complainant when everything is done remotely. This downside requires investigators and Title IX coordinators to be all the more savvy. Building trust can occur in a variety of ways. First, you want to ensure that you re-emphasize your policy and your procedures throughout the investigation to ensure that all parties fully understand. Now, you may have complainants who decide they aren't interested in pursuing an investigation right now, as they have greater stresses or other obligations due to this pandemic. You cannot make this determination for them. Also, you may decide, as allowed by your policy, that the allegations are serious enough that the investigation cannot be delayed, even if the complainant has some concerns about pursuing the complaint right now. However, to the extent possible under your policies and the facts of the case, you can be flexible with both complainants and respondents in terms of deadlines. This recognition of the unique demands of the pandemic can help further trust, so long as you don't, even if inadvertent, deprioritize the complainant's allegations or either party's rights. You don't want the parties left with the impression that their rights aren't important because of the current pandemic. They have the same rights they've always had. Now, this may seem incredibly basic, but you want to ensure confidentiality and professionalism. You need to make sure the setting in which you're conducting your interviews provides privacy to the parties, even if you're conducting your interview from your home. Another issue we anticipate arising with all students remote is the parties' access to internet, willingness to answer calls or check email, and capability of finding a private space to speak with you. Some investigators may be more comfortable with the complainant having access to the investigator's cell phone number, which allows the investigator or Title IX coordinator to reach out to the complainant via text to remind them to check their email to set up the interview. Another option for those of you who aren't comfortable with the parties having your cell phone number is to create a Google Voice number, which allows you to send a text from a different number to track down students to set up an interview. You should be flexible to the extent possible with finding time to speak with the parties. You also need to take care to ensure that the parties have access to the web tools that you're using.
Mary, I just wanted to jump in on one point that you made that I think is an important one. We have had a lot of success in reaching out to witnesses and parties who have been difficult to track down remotely through text message. But one thing you all need to be keeping in mind is, from a litigation perspective, is that if you are texting with parties or witnesses, even just to secure meetings, potentially that information on your cell phone could be discoverable or something that is subject to review in litigation. So we really like the option of, instead of using your own personal cell phone or your work phone, is to use the Google Hangouts or some other form of texting tool that you can use through an online platform as opposed to directly through your phone. It's a great way to get them to make sure that they're paying attention to their email or sending them reminders for meetings, because we know that they're paying attention to their phones. But at the same time, we don't want to create any exposure for you that your entire phone may be subject to discovery in a lawsuit.
Okay, thanks, Julie. And so back to the technology tips. We've seen a variety of technology used successfully and not so successfully in remote investigations. We're not endorsing any of these products in particular, but rather just providing you with a variety of ideas. The most important thing is for you to ensure that the AV system you're using is reliable and that both you and the interviewee are familiar with it. You need to make sure that whatever you're using, you can use it successfully. You also need to be concerned about encryption and security. For example, we know that you can set up Zoom, which we've used successfully, in a way that a login passcode is required so that nobody else can join. This is a useful practice to adopt, as we've heard horror stories, luckily outside the Title IX context so far, about various work meetings using Zoom without a passcode and having interlopers from outside the company jump in and derail the meeting. So you just take steps to make sure that whatever tech system you're using is secure and private. You should talk to your CIO, your IT department, about which tools are best for your university and about any security issues or privacy concerns you have. Also, in regards to recording interviews, you should stick with your past practice. If your policy says to record, you should. If it doesn't, you shouldn't change that practice now. One thing we want to note is that you should not use the recording feature on an external platform without fully vetting how that sensitive information is stored. For example, if the web-based platform you're using to interview someone stores the recording on their own platform and it's vulnerable to being hacked, that's a huge security issue. Again, talk with the folks who specialize in this at your university to figure out whether the web system's recording tool is a good idea. As a best practice, you should continue to record interviews using the same tools you previously used, whether that's a tape recorder or your own phone. There's also a variety of document sharing platforms. We know that many of you simply use email, and that's fine to continue using. However, for those schools that rely more on in-person document sharing, some of these tools on this slide may be useful, and we'll talk about them a little bit more in this presentation. And now I want to give you some best tips for conducting remote interviews. Our first best practice for conducting remote interviews is to control the environment. You need to keep the interview professional and confidential. We've all been in meetings these past few weeks where kids or dogs pop in, which can be great for levity in internal meetings. I know, for example, that I've been on internal video calls with a cat purring in my lap over the past couple weeks, but it isn't appropriate for these serious sorts of discussions. Pay attention to what the interviewee can see of your environment. Not only do you need to make sure you're dressed professionally, but what artwork is on the walls behind you? Can they see a lot of your house? You should test out the video frame before you get on the call to make sure you know what you're showing. Another important part of controlling the environment is to ensure you're comfortable with the AV platform you're using. Phone a friend beforehand to test it out. Make sure you're comfortable enough with how it works so that you can advise the parties or witnesses if they're having tech difficulty themselves. And build in some time in the interview to allow for any sort of troubleshooting. Another thing to note, which again may seem very basic, is to pay attention to time zones. Make sure you know where the interviewee is located and what time zone that is. Email calendar invites should take care of time zone differences for you, but you want to make sure when you're originally scheduling the interview that you're clear about what time zone you're scheduling it in. Another thing that's really important to note is that the parties have the same support person and break entitlements during a video interview as they do in person. Make sure the parties know that they're entitled to a support person and that the support person does not need to be in the same place as them. You can add multiple persons to any of these platforms we discussed before. If the complainant or the respondent provide the contact info for their support person, you can send that support person the necessary login info or add them to the meeting so they can show up to support the individual even if they're located elsewhere because of this pandemic. Finally, willingness to participate is an issue with remote interviews. It's already tough to get a hold of witnesses during a normal investigation, and now we have students flung across the country who may not feel that participating in an investigation is important right now. We recommend that you rely on the parties to get the contact information for witnesses and to track them down. If you're having trouble setting up interviews with witnesses, you should review your student conduct processes to determine whether students are required to participate in interviews. There may be ways of encouraging student participation through these various processes. Finally, document how and when you reach out to witnesses and cite your attempts to do so in your report if the witnesses do not respond. Now, regarding issues that arise outside the interview context, one question that has arisen is, how is physical evidence shared? Electronic evidence is more easy. Universities can utilize tech tools, such as a Box account, through which students can upload screenshots of relevant text exchanges or emails, etc. And of course, you need to make sure the privacy settings of these platforms are properly set. However, with actual physical evidence, it gets trickier. The Title IX coordinator, the investigators, the parties or witnesses will need to figure out what can be sent electronically, what can have a picture taken of it and sent, and what, if anything, needs to be sent via mail. As with evidence, there are also issues surrounding the sharing of preliminary reports. We know that some schools already have the practice of emailing the parties the preliminary report, and COVID-19 won't change that for those schools. However, some schools only email a redacted report and permit students to view the unredacted information in person only, and even others only allow students to review any of the report in person. This in-person review likely can't happen right now, but under your policies and procedures, students still have the right to review and respond to the preliminary report. So what do? There are some tech tools discussed before that can help you. You can also, especially if you're one of those schools that usually requires in-person only review, redact the parties' names or use pseudonyms in the report. However, as I said, you're still going to need to provide students with an opportunity to review the unredacted information. And one way to do this is to, upload it to a Box or Google Drive or OneHub, similar tech tool, but it begs the question, how do you ensure that students don't download it? First, you can rely on your policy and practice. Just as you do for students reviewing the report in person, you can stress to them that they are not allowed to copy or take photos of the report. Second, many of these tech tools have lockdown options, which block the report from being downloaded or printed by the viewer. Now, these tools won't stop a student from taking a picture of the report on the computer with their phone. That's when you go back to the policy and make sure it's clear to students that this action is prohibited. You may also be able to get a little creative. Could you arrange a socially distanced visit to a partner institution near each party? For example, another university, a mediation center, a law firm. Now, this may not be practical or even possible, but especially for very sensitive information where you think there's a high risk that the information may be shared in violation of your policy, it may be worth exploring. On this last note, we've seen some schools beginning to explore the use of waivers or acknowledgement forms as a means of addressing some COVID-19 related Title IX issues. In some contexts, waivers may be useful. For example, if you normally only allow students to review certain evidence or reports in person, and as a policy don't provide copies, it could be useful to have students sign acknowledgements that any reports or evidence they're being provided copies of now, for example, via email, are required to remain confidential and cannot be disseminated. However, we have some concerns with other waivers being used. We've heard schools exploring the idea of having the parties sign waivers acknowledging a difference of procedures due to the pandemic. To the extent possible, we advise sticking with your normal procedures. While certain adjustments must be made, for example, if your policy provides that certain meetings happen in person, those will now need to be remote. But you shouldn't completely depart from existing practice. So at this time, we don't advise amending your policy and procedures or asking the parties to actually waive any of their procedural rights. Stick with your procedures to the extent possible. And while it's smart to document the reason for any departures, as I said, there are some concerns about waivers and whether they could create additional problems for yourself. With all that being said, we think waivers can potentially be useful to the extent procedures are modified or delays are occurring. However, you have to be careful you aren't creating unintended consequences for yourself. And if you're exploring this, we advise that you talk to your legal counsel about it. Also, it's important to note, as we said previously, a blanket postponement of all investigations until next semester or until students are back on campus is not advised. Now, one other thing we wanted to note for you about modifications to policies and procedures has to do with live hearings. For our schools doing live hearings with cross-examination now, you might have to get tech savvy about this. It could be that these proceedings are essential and should be conducted in person with social distancing. However, with students and witnesses at home from campus, it might be easier to conduct remote hearings. This is going to probably be one of the tougher issues facing Title IX coordinators in the age of COVID-19 for those universities that do have live hearings. And we really recommend you talk with your counsel about the best way to handle any hearings you currently have scheduled or any hearings that you are likely to happen in the next couple months. Okay, so let's talk about interim measures briefly. As you know, interim measures are required as part of the effort to avoid depriving any student of his or her education. The obligation to provide interim measures continues even during this pandemic as students are off campus. Now, generally speaking, the measures needed by each student may change over time, and we anticipate that some parties' needs will have changed by virtue of COVID-19 alone. So it's worth revisiting the interim measures provided to students in light of the current pandemic and in light of students' departures from campus. Referrals to campus-based counseling services are one example of an interim measure. However, with students now off campus, new issues around campus counseling have arisen. Individual states have their own licensing requirements and specific rules regarding telehealth services. Now, long-distance therapy using audiovisual or telecommunication devices is a form of telehealth. In-state telehealth services are often governed differently than interstate services. In many states, in-state telehealth is allowed so long as the provider is complying with their ethical obligations and any insurance and HIPAA requirements. Interstate telehealth, however, is generally regulated by both the state in which the provider resides and the state in which the client resides, as well as those HIPAA and insurance requirements. Now, a number of states' state of emergency declarations have relaxed these requirements, effectively allowing across-state telehealth for a limited period of time to ensure continuity of care. The federal government has also indicated it will relax telehealth requirements along the same. While it's unclear whether the federal government's declaration would apply to telehealth provided by campus counselors, it may. So in the event that your campus counseling centers are going to be providing telehealth, whether as an interim measure for a Title IX complainant or just generally, they should look into both what the home state is saying about telehealth and what the state in which the students receiving counseling reside says. Another telehealth consideration that you need to bring to campus counseling's attention is regarding HIPAA. We've talked about AV platforms early in this presentation. Pre-pandemic, there was a greater concern about HIPAA compliance with these platforms. Only certain platforms were HIPAA compliant, and those were the only ones that could be used. However, HHS has stated that it will not enforce certain HIPAA requirements related to the good faith provision of telehealth during this pandemic, which may enable your campus counseling centers to more easily and quickly begin providing such services. We also want to note, though, that there are liability concerns with telehealth. You need to discuss with your university's risk management about your liability insurer's requirement for the provision of telehealth and whether certain platforms must be used or avoided. In the event that you are going to provide teletherapy as an interim measure right now, either for students who have been receiving campus counseling or for new complaints that come in, we advise that you take some key steps. As I just said, you should ensure that your liability insurance permits teletherapy in these circumstances, and you need to determine the scope of this allowance. You also need to communicate with students about the need for their insurer to allow teletherapy in the event that this service is billed to the student's insurer. It's likely, but not certain, that telehealth will be covered by your student's insurance, so they just need to check themselves. We advise having students sign consent explicitly for teletherapy, and that this consent addresses both the insurance and any privacy issues. This needs to be informed consent about the risks of teletherapy, particularly in regards to privacy and about any cost to the student. And another interim measure that's frequently given is, of course, community referrals. However, in light of the current pandemic, these community referrals may no longer be relevant to a student who is now states away. So you need to look at whether the community resources you typically use are capable of continuing to address the student's needs, and if not, help that student find other resources. During a time of crisis like this, relying on and building out a community of practice can be really beneficial. We advise that you tap into your network of higher ed administrators and Title IX coordinators and inquire about what community referrals are made by the universities in the area in which the student is now residing. Does a more local university have on-campus services that can be made available to that student? Are those community resources that have been vetted by the more local university, and can their partnership be used to get that student connected with that resource? The practice of coordinating with professionals at other universities will be useful beyond the community referral context. Your community of practice can help you address novel issues that are going to arise in light of this pandemic. And as you know, when a complaint comes in, you provide the parties with their rights and options. You should consider adding a provision to those rights and options about helping the student find resources local to them. If you typically send out community referral info in your area, you may want to include a notification that the student should contact the university to find support that's in their area. You want to make sure the students are getting the message, we are here to help you. Now, we have another poll question for you. This is a hypothetical. Ongoing investigations aren't going to be the only issue that you're facing. You're likely going to get new complaints during this era of remote learning. Before we get into a few best practices for responding to new allegations, please respond to the following question, which addresses virtual misconduct. It's about an infectious disease vaccine development class, which is now an online class. One student who is home in New Mexico sends a pornographic link during class via the chat feature. Should this be investigated under your Title IX policy? Yep, it looks like most of you have said yes. So first, just to note, we're in a bit of a limbo here about the reach of Title IX or a university's jurisdiction over Title IX complaints in terms of remote learning off campus. I'm sorry, not remote learning, but in terms of off-campus conduct, especially with students, flung across the country. We had expected that the new regulations would narrow a university's jurisdiction. However, they haven't dropped yet. So you're going to really need to rely on your policy to figure out the extent to which complaints that come in about off-campus conduct implicate Title IX. Of course, as a preliminary matter and as teed up in this hypothetical, virtual conduct that happens during a class definitely implicates Title IX. In the hypothetical we just looked at, the misconduct occurred during class using a class-based discussion tool in front of the professor and the entire class. Just because the students were in different states and they weren't physically together doesn't mean that this isn't a violation of your policy. We've seen cases arise out of the online class environment before, and it's important that they're investigated just as fully as cases that arise out of an in-person class environment. And as you know, any sexually harassing conduct that affects a student's access to education should be investigated. And of course, your responsible employees are still responsible employees in the online environment. The new or should have known standard, which as you know applies to deliberate indifference claims brought against a university for violations of Title IX, applies to virtual conduct if the university knew or should have known about it. Obviously, it might be harder to know about conduct occurring off campus in this remote learning era than on campus, but certainly any in-class misconduct and any misconduct reported to a responsible employee should be investigated. However, you might get complaints that don't implicate the educational environment. You might have students who experience misconduct in their home communities, not involving other students or faculty. You also might get allegations related to social media. While your Title IX policy may not be implicated, you should still provide community resources and referrals to students coming forward with complaints of sexual harassment or misconduct, even if it's unrelated to the university, just to support those students. And of course, as you get complaints in which it's challenging for you to determine whether or not your Title IX policy is implicated, we advise that you check your policy and you make sure you ask legal counsel about any tough calls. And I'm going to turn it back over to Julie to give us a little summary of some best tips for Title IX coordinators in this pandemic age.
Thanks, Mary, and thank you for all this useful information. We know that all of you on the call may be coming to this conversation from a different place. Variability across higher education is one of the beautiful factors, I think, of our field. So we know some of you have already been working with these online tools. Some of you are already sharing reports electronically, or some of you have not been doing that. So we want to make sure that we're providing takeaways for all of you to be thinking about your unique environment and how this pandemic that we're facing and all of the challenges that come along with it need to be taken into consideration against your Title IX practice. So to summarize what I consider the top 10 takeaways from this portion of our webinar is we think it's important that if you haven't already, you need to be engaging in conversations with your leadership to make sure that they understand the continued need to conduct investigations, respond to complaints, and if there needs to be modifications to how that is typically happening on your campus, given a shelter-in-place order or given a close or moving everybody to online, it's important that Title IX coordinators in particular are having those conversations with leadership now so there are not surprises. Another thing is to make sure that you're learning the available technology tools and their features. The features in particular are very important, and they can provide some additional benefits that you may not know are currently available that can really aid in your investigations and your conversations with parties and with witnesses. I've already previewed some of the questions and answers that were coming in during Mary's portion of the webinar, and I can see that there's a number of questions around, well, should we be using the audio or the video component of these tools? If you are embracing this technology, we recommend using the video feature. We have done that, as Mary said, in remote settings where we are video or Skyping with a number of witnesses and parties. And that is the best way to build that rapport and that trust that you need with both parties, with witnesses, in order to get the information that you need. So learning the features and making sure all of your investigators are aware of those and how to use them is important. One thing I like to ask all of you to consider is whether or not your rights and options may need to be updated in a way to provide some notice about your institution's commitment to helping them find local resources if you have students, again, as Mary said, scattered to the wind across the country. I'm not saying that you have an obligation to go this far, but we know most universities and colleges that we're working with are trying to navigate in providing support and resources for their students, which that still is an obligation. But when they are in different places across the country, that gets much harder. You've already put a lot of time and effort into preparing your resources and building those relationships with community providers that you know where to go. But if you've got students in other parts of the country, other parts of your state, you may need to be really thinking about your own relationships, your community of practice with your peers in other areas so that you can maybe reach out to them and make sure that your students are getting the resources that they need in their areas. And so if you're going to do that, it may be worth updating your rights and options to make sure that you're emphasizing the willingness of your institution to support them in that. Another one is to make sure that you're level setting with your whole investigation team on any virtual interview strategies, techniques, approach. It's important that you all have conversations. For those of you that have teams of investigators, and I know we have clients who are lucky just to have one because they're much smaller schools, but if you have multiple people doing this work at the same time, it's important to talk to them about how are they using the technology tools, what is their approach, what extra measures are they taking to ensure that there's fairness in the process and transparency about the challenging time that we're in and how that can affect investigations. 5, it's important to identify protocols for sharing reports virtually. Mary talked about this. This is for, I know that there was a smaller majority or smaller number of you, not the majority, that have not been doing this, have not been sharing reports virtually. But if you're going to continue with investigations, the sense is that you will get to conclusion on those and you need to be ready for how are you going to satisfy this compliance requirement. 6, be knowledgeable about what your virtual capabilities are for advocacy and counseling teams. You want to, if you're a Title IX coordinator, make sure you're aware of what they can do, what they are doing, and what the university is allowing them to do, and how that impacts your referrals for those services at your institution. Ensure and recommend consultation with IT or your CIO on the use of any technology tools. There are unique security encryption risks that every institution's IT team, while I know they're probably very overwhelmed right now with moving to an online learning platform, this is an important issue that you want to give them an opportunity to weigh in on. I know that we have, even just amongst our own team, we have, there are preferences within our firm of what our IT team would prefer us, what technologies our IT team would prefer us to use, and it's important to check in with those folks and make sure they have a seat at the table on those decisions. 8, ask whether your institution has a heat map identifying displaced students. This may be very difficult for you very large institutions out there with tens of thousands of students. But for those of you with a smaller population, your student affairs department may already have this. Just getting a sense of where are there clusters of students, either across your state or across the country, may help you better prepare for providing resources and support to students that may be contacting your office for help. Plan to over-communicate. You cannot, in a time like this, you can't over-communicate with your parties, with witnesses, with individuals who are receiving interim measures. Just plan that more communication here is better, because even in a time of disaster like this, when we're all trying to give each other the benefit of the doubt, When the disaster subsides, we still see complaints and disappointed parties and folks who want to challenge decisions that were made. And so it's important to make sure that you're protecting yourself by over-communicating any delays, any changes in scheduling, etc. Last, be ready to get creative, think outside the box, and be ready to rely on your partners, your legal office, your IT team, your student affairs. Make sure they're all getting a seat at the table as you're dealing with novel issues, particularly legal, because again, to my earlier point, even though we're trying to give each other the benefit of the doubt now, down the road, that is a feeling that may subside if you have parties who are disappointed with outcomes of their cases. So with the time that we have left, and we do want to provide some opportunity for questions, particularly on the COVID-19 impact to your Title IX practice, when we were planning this webinar, we were really seeing some common problems that were playing out negatively on campuses, but at the same time, we were seeing schools really experimenting with similar approaches to try to address those issues. And we've pared this down a little bit, but we want to still highlight what we think are some newer trends that if we were in going into a normal summer with no pandemic, with no radical regulatory changes potentially on the horizon, these would be the issues that we would be recommending that Title IX teams think about over the summer and try to make some progress on. So to get into these, just to highlight, we're going to cover three, which are sanctions, education and training, and impact on graduate programs. So the first one is the bigger issue. We have been seeing lots of issues related to sanctions that are coming back to sort of haunt institutions after we complete an investigation, after we issue a sanction, and we think we're done. One of the common practices that we have observed is that institutions often grant pretty wide latitude to sanctioning officials. A case is done, the investigative report is put together, a finding is made, and then a sanctioning official is taking a look at that and essentially picking from a very large menu of potential sanctions that could apply. The problems that we have seen play out are these: a lack of consistency in sanctions for similar circumstances, a lack of clear explanation, including a written record of why sanctions were reached, especially if they were differing in similar circumstances. And a third is a failure to address expectations following disciplinary action. So you have somebody, a respondent, who's going to be facing some kind of disciplinary action that results in a temporary separation, and now we have a reentry of that individual, and we don't have everyone on the same page about what that reentry is going to look like. Those are the issues that we've been seeing play out in a negative and public way for schools, and they arise through appeals and subsequent legal challenges. So we want to set you up for some fixes that we know some schools are exploring. So the four trends that we're seeing to try to address these sanctioning problems are: one, enhanced training for sanctioning officials, which we'll get into; two, tracking sanctioning decisions and evaluating for overall trends and problems; three, development of sanctioning guidelines and matrices; and four, addressing expectations following disciplinary action. So we're going to go through these quickly. The first one is enhanced training. We are seeing our institutions pull together their sanctioning officials and really go deep on what it means to issue a sanction and how they get there. There's a lot of concentration on making sure that your sanctioning officials understand what are mitigating and aggravating factors that may warrant a reduction or an increase of an appropriate sanction, and how they document that sanctioning decision. How do they describe and memorialize how they arrived at that decision? That, to me, is the best piece of evidence that you have that a sanctioning decision was reached in a reasonable way. If somebody has a written explanation of how they got to a conclusion, they should be entitled some deference for that decision. Aggravating and mitigating factors, we're going to share this slide. I know a lot of you already are well aware of this, and it's just a matter of training your sanctioning officials to understand these. So we have a list of these and how they can potentially impact sanctioning decisions. I'll let you review those when you take a look at the slide. Trend 2 are sanctioning guidelines. We are seeing institutions across the country experimenting with the development of these matrices that essentially provide a range of acceptable sanctions for specific offenses. And they may also provide examples of the type of misconduct that complements the definitions that exist in your policies. The common challenge, though, is when institutions take on this effort to develop a matrix or a sanctioning guideline document, is that there may be a contingent of stakeholders who want to see something very highly prescriptive. Some may feel that if you just tell me what the right sanction is, then I know we can apply it right. Others may feel that any kind of offense in a certain category absolutely requires a certain response of a certain sanction. This concern is one that we want institutions to be very careful about making sure that they're managing well, because an approach that eliminates all discretion for your sanctioning official may be too formulaic, and it can be very difficult to defend later. Essentially, think back about a decade ago when you were hearing the no tolerance, we have a no tolerance or zero tolerance policy for bullying or for physical misconduct on campus or in the K-12 setting. Those were the kinds of decisions that were routinely challenged. We have to make sure that we are being thoughtful about our sanctioning decisions, and we are not just putting this through a formula, but we're actually arriving at the right result. So the best practice is to use these sanctioning guidelines as advisory, but make sure you're preserving that discretion. A third trend is making sure that if you're going to have a temporary separation with a faculty member, a staff member, a student, is that you are setting forward the expectations for reentry and any limitations on that individual right at the beginning. That sanctioning decision needs to cover what it looks like when that student or faculty member or staff member comes back. If that is, for instance, a student who participates in an extracurricular or a sport or some form of student leadership, and that's a privilege that's going to be taken away, we need to communicate that now at the sanctioning stage, and not when that student comes back. That will eliminate confusion and hopefully ensure that there are no problems. Okay, so the last trend we'll get to is making sure that there's Title IX coordinator oversight of those decisions and some tracking. Some institutions have started to move to this. I know you Title IX coordinators are probably gasping right now, because I know how difficult this can be, particularly for those of you who have sanctioning decisions that are made at different parts of the institution. They may be essentially delegated out to your supervisors within departments, for instance, for faculty. We are seeing a trend where Title IX coordinators are trying to get a better handle and actually start tracking what was the violation type, what was the sanction, what were the mitigating or aggravating factors that may have resulted in a certain discipline, and essentially tracking that information. One of the benefits of this is over time, you may be able to see any trends that you feel need to be addressed. For instance, if you have faculty and staff just being treated differently, that's an evidence point that you can use to try to dig in on looking at how those decisions are being made. Of course, you can see race and gender are here on the slide. Those are some categories that institutions are considering looking at and making sure that we don't have any kind of implicit bias in our decisions. I will tell you, this is very difficult to do. It's also touchy. When you have this information, you may have obligations to make sure that you are responding to this. If this is something that you want to do, my strongest piece of advice that I can leave you with is please consult with your legal counsel on how you do this in a way that you're getting useful information, but you're not taking on unintended consequences that are only going to hurt your Title IX practice down the road. You want to do this in a measured way that's giving you the benefit of that information without creating more problems. I will just, since we only have 5 minutes and I can see we have a lot of questions coming, I will just highlight the last two pieces that we wanted to cover for you. Is we are seeing a significant trend in taking the current training approach for Title IX, which is often students often are reporting to us that it feels like a check-the-box exercise where we have an online 30-minute portal. We log in every year, we go through our training, and that's it. This is the kind of training that is often seen as the floor. We do this because we need to offer something so we're compliant. It's often seen as mandatory. We do it every year, and it's often the same training. Time and time again, when we're on campus and hearing students concerned about Title IX practice, sexual misconduct and harassment on campus, one of the biggest things that they point to is that our training is not effective. And a number of schools are moving in a different direction to try to get away from that and provide and deliver a better product, essentially shifting the idea away from training to actual education or professional development, so that there are more touch points. It is about shifting culture, not just checking a box. And we're seeing a lot of success out there. The last issue I will just briefly touch upon is special considerations for graduate programs. We have seen so many cases out there that impact graduate programs or graduate students, and it's important that we are, as a team, as a sector, really considering all of the variables for graduate programs that are being impacted when there is a Title IX investigation involving that space. There are a number of dominoes when we are investigating a graduate student or a fellow, a resident, a PI, or a PhD advisor. That is a really tightly knitted community, and there are all kinds of concerns, particularly if we're temporarily taking out a member of that team, that starts to affect an entire team. So one of the things that we have seen that we are trying to recommend our Title IX coordinators really get on top of is making sure that those considerations for graduate programs are being taken into mind. You may need to partner with a dean or a department chair to fully understand what sort of dominoes could be falling down in the event that you have an investigation affecting a graduate program. For instance, continuation of funding and purchasing. If somebody who's in that chain, in that group, who controls that matter, is the rest of the graduate program able to continue their research and purchasing? It's a niche academic area that is often the biggest challenge, where you don't have a lot of other faculty advisors who can step in to fill the hole of somebody who may be missing. What do we do with the recruitment of new students, and how do we communicate that while we are in the midst of an investigation? These are unique circumstances for graduate programs that I know we are going to continue to talk about in the weeks and months ahead, and we're happy to share some lessons learned for some of the cases that we have handled with respect to graduate programs. So this is one we just wanted to make sure that you were all thinking about. So we have just a few minutes for questions, so I'm going to quickly turn it to Mary Jones so we can tee up some of those, and if we don't get to them all, we will respond to those via email over the course of the week. Thank you.
Thank you, Julie. Thank you, Mary. And we are not going to get to all the questions. We're already almost at time, but let's do a few of them, and especially the ones that we've gotten multiple questions about. One of them, and I think this one would be from Mary. Mary, a lot of people are asking, do we have to provide them a copy? Can we share our screen? Would that meet the requirement of providing this information during this Title IX investigation?
Thanks, Mary. So that's a great question. What we talked about is it's important that you stick with your past practice and procedure as much as possible. If you generally, sit with one of the parties when they're looking at the unredacted preliminary report, then I think it's perfectly reasonable to do a screenshot, type tech tool. It will require a little bit of, for lack of a better word, babysitting the part of your Title IX coordinators or other staff, just to, kind of sit there on their computer while the respondent or complainant is looking at your screen. One concern I have with this approach is that to the extent you allow the party or their support person or their attorney to look at the preliminary report, in the Title IX office, without a Title IX coordinator or investigator there with them, you might run into some issues that you're not giving them that same, for lack of a better word, alone time with the preliminary report at that time. But it's something just to think about. It just depends on how your past practices work, and whether that's something that you have the capabilities to do right now.
Great, thank you. We also had several questions about handling the in-person hearings with social distancing. A lot of schools are not on stay-at-home orders, but they're doing the social distancing, even though they might be remote. Can they be required to provide in-person hearings with social distancing? Can they require a virtual meeting? Can they make that decision? And also, a few people have asked, what if the respondent or complainant doesn't want to be on video? Can they make that decision, or is that a requirement that that the school can make? So kind of a little bundle of questions around these requirements for virtual meetings.
Mary, why don't I take the second question, and then we'll turn it back to Mary D for the first one. The second question is whether or not we can require parties to participate through the video feature, or whether we're just doing these remotely via audio. When we've had this in the past come up where we've had a reluctant party who does not want to be seen on video, we have typically honored that, but we first try to educate the individual about why that can be helpful. I always like for anybody that I'm interviewing to see me. I think it humanizes me as opposed to being just some investigator out there in the ether who they don't know and who's not connected to the university. So we try to encourage that it's just a way for them to see us and for us to see them. I know I've seen some questions come up that a lot of you have concerns about. If you can't see somebody in person, how can you assess their demeanor and their credibility? And I would just remind all of you that demeanor is often the least important factor for making a credibility determination. One of the things that we like to see in reports is we want to see investigators writing to consistency, to corroboration, to lack of motive, and that to the extent that you have to rely on demeanor to make a credibility determination, that you're doing that in as small and minor of a way as possible. So that is our recommendation, and so that if you ultimately have a party who does not want to participate on camera, that we often are comfortable allowing that to go forward, but each institution will need to make its decision and just apply consistently and fairly for all parties. Mary, do you want to take the other one?
Sure. I'm going to echo actually a little bit of what Julie just said about, each university needs to make these decisions for themselves based on, the facts of the particular case. For our schools that do live hearings, which again isn't all schools, but for those of you that are doing live hearings, it's going to depend on the unique circumstances of whether your state has a shelter-at-home order in place, whether students are local. There's a lot of considerations about whether or not you should go forward with a live hearing in person, or you should do it remotely via video. And of course, you might need to delay it a little bit. As we said earlier, you shouldn't, postpone everything, but a little bit of delay probably makes sense. Although there are concerns if, the respondent is subject to interim sanctions right now, interim measures that involve, like an interim suspension or a registration hold. Any delay on the actual hearing is really not advisable. So I don't think we know for sure yet whether the answer is you have to have a live hearing or you can have a live hearing. Now, if the university is not if the state doesn't have a shelter-in-place order, the parties are local, the university and the parties want to go forward with a live hearing, as long as you socially distance, we think that is something that you can make the decision to do. If the parties all agree to a video hearing, great. I think the issue is going to be where the parties want something different than what the university wants, or the parties want something different from each other. And you're going to have to just take care, and Julie might want to add in on this, but take care to ensure that the procedural rights of all the parties are guaranteed as much as possible, and take it on a case-by-case basis.
Yeah, agreed. What I would just say to put a period on the end of this is that you've just got to think ahead of if somebody's going to challenge or argue that the process was unfair or that they were forced into something that they didn't want to do, how are you going to be able to defend that what you did was reasonable under the circumstances, that it was communicated, that was equitable for both parties, et cetera, et cetera? If you're thinking like that, you should be able to come up with a solution that in this sort of unknown time at least is defensible. And if you really are struggling, that is where I would certainly recommend consulting with legal and making sure you're all on the same page about a plan. I know we're at time, so I'm going to turn it over to Mary, but I have just went through the questions and I saw a number of recommendations on technology tools from some of our clients who are suggesting that OneHub is another tool that they really like as a way of I think OneHub is actually to host the meetings, and I think you can also share information through that tool. So I just want to share that with you. We have a number of questions to answer, and we will be getting those to you back via email over the course of the week. I want to thank you for participating. I know Mary has a few closeout pieces of information, including an upcoming webinar this week for us to be talking more about COVID-19. So Mary Jones?
Thank you both so much on behalf of everybody. We really do appreciate your time and also everyone's time today as we all grapple with these challenges that we're facing. So if you haven't already, check on the survey. Please click on the survey icon at the bottom of your screen, and there's a brief survey to give us some feedback to help us in providing future programs. And Julie mentioned the webinar. We have a webinar Thursday, April 2nd at noon Central. We're doing a town hall where we're covering higher education issues in COVID-19 and answering questions that you submit to us ahead of time so we can answer those questions. I know some things are keeping you up at night, and Julie Maselli and many other attorneys will be answering your questions. And so we are looking forward to that one on Thursday, April 2nd. This program has been approved for Colorado, Illinois, Iowa, Kansas, Missouri, Nebraska, and Tennessee for continuing legal education credit, and pending approval for Indiana, Texas, and Wisconsin. So again, you've got that certificate of attendance you can download from the certificate widget. And I noticed there were a few audio issues, but know that you're going to get a complete recording of this, a link to that you can get, that you'll be able to receive tomorrow for watching and sharing and making sure you saw everything. So I think that's everything we do. Thank you once again, Julie and Mary and everyone who attended. I wish you all the best during these challenging days. This concludes our webinar. Thank you.